This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about insurance fraud and politics, where a U.S. Senator was charged with insurance fraud and other crimes and sought to fight search warrants that developed evidence against him by claiming they were improper. The U.S. District Court in the United States of America versus Robert Menendez et al., a March 4, 2024 decision of the Southern District of New York, dealt with attempts to defeat the search warrants that found evidence that Senator Menendez, a Democrat senator for the state of New Jersey, was involved in selling favors to a foreign country and insurance fraud. Menendez moved for a Franks hearing to assess allegedly material misstatements and omissions in the government's search warrant applications and an order suppressing evidence from additional warrants seeking electronically stored information on the grounds that they are generally unconstitutional warrants. The years-long investigation that led to the indictment in this action involved the issuance of numerous search warrants for both physical locations and electronic devices or accounts. Menendez challenged a subset of the warrants. Menendez's challenges of 3 warrants are on the grounds that the warrants were, quote, riddled with material misrepresentations and omissions that deceive the authorizing magistrate judge. The district court noted that the Fourth Amendment of the U.S. Constitution provides that, quote, no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Thus, a warrant may not be issued unless probable cause is properly established and the scope of the authorized search is set out with particularity. With respect to intentionality, the reviewing court must be presented with credible and probative evidence that a misstatement or omission in a warrant application was designed to mislead or was made in reckless disregard of whether it would mislead. The evidence supported probable cause as to Menendez's involvement. Within 2 hours of the call from Menendez's office to the official, Mr. Hana texted Nadine Menendez asking for her address, and only a few days later, Nadine responded with, quote, I'm so excited to get a car next week, close quote. In addition, the affidavit cites a message from Nadine to Hana indicating that Nadine had forwarded the materials related to Egypt to Menendez. In summary, the warrant application amply satisfied probable cause, and adding any omitted information contained in the transcript of the confidential source would not alter that determination. Contrary to Menendez's assertion, the second affidavit includes additional evidence supporting probable cause, including messages from a person named Uribe asking Hana for help disrupting a New Jersey investigation into insurance fraud. Therefore, as with the January 22 Menendez warrant, the court denied Menendez's request. The court concluded that the omissions are not material. The inclusion of additional information would not change the probable cause determination. The New Jersey defendant, the jeweler, and the testing company owner are all alleged beneficiaries of a bribery scheme. The fact that beneficiaries of an alleged scheme denied their involvement or knowledge after the fact when questioned by a government agent is not sufficient to overcome the significant contemporaneous evidence supporting probable cause that is otherwise present in the affidavits. Menendez has not provided any evidence, and there is no basis to infer that omissions were intentionally or recklessly misleading. Indeed, the government only learned the relevant information on the same day that the warrant was sought, which cast significant doubt on the claim that its omission was designed to mislead. Accordingly, the court concluded that each of the omissions does not meet the materiality threshold, and moreover, the combined cumulative effect of the omissions raised by Hana and by Menendez, including those that were raised by all of the parties, does not rise to the level of the substantial preliminary showing required for a Franks hearing to determine if the warrants were properly issued. The court also found that the Menendez warrants satisfied the requirements of particularity. Menendez took issue with the breadth of iCloud account collections, but it is well settled that the government may seize the entire contents of electronic accounts in order to search for relevant evidence. In sum, the Menendez warrants are not violative of the requirements of the Fourth Amendment. In conclusion, the court found that Menendez's motion to suppress search warrant returns was to be denied, and additionally, the challenged Menendez warrants do not violate the Fourth Amendment's particularity requirement. In my opinion, when a United States Senator engages in acts to protect a person committing insurance fraud and providing assistance to the country of Egypt was an act outside what one would expect of a U.S. Senator, and was subject to search warrants that allowed the search of his home and seizure of evidence of his fraud and inappropriate conduct to favor for a fee in gold the concerns of a foreign country. He attempted to have the search warrants eliminated and the seizure of evidence during the searches conducted, and that attempt clearly failed. This case establishes, among other things, that insurance fraud is committed by every race, religion, gender, national origin, wealth, or service in public office, and is rampant, and in this one rare case has resulted in an arrest. Whether it results in a conviction, we must wait for the trial. This video was adapted from my blog, Zelma on Insurance, which is available to anyone for free who clicks on the URL zelma.com/blog, where you can subscribe to the blog and you'll be notified of every blog posting, usually 5, sometimes 6 a week, and you'll have access to the more than 4,750 blog posts. You can also subscribe to the videos, also for free, on rumble.com and youtube.com. And we'd appreciate it if you tell your friends and colleagues about the blog and the videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.